technically a family or household member. And then if you've been cohabiting with this person, so if you guys have been living together, whether or not you were ever married, that's another that falls under the definition of a family or household member. So to get a protection order for domestic violence, you can go to the courthouse, you go to the clerk's office, and they have carbon copy paper forms, and you'll get what's called a petition. And a petition is your chance to tell the court your side of the story and ask them to do something for you. So you fill out the petition, and you allege whatever form the abuse took. Was it physical, was it sexual, was it forced imprisonment, was a combination of those things. So you'll want to be very clear, put the date, anybody that was there, you want to put that in the petition. Then you describe in as much detail as you can what happened, how were you injured, how were you abused, or how were you held captive. You file that with the court. There are no filing fees associated with protection orders. That's not allowed under federal law. So their protection orders are governed by federal law as well as state law, and on the federal level, to make it so that more people feel comfortable getting protection orders, they have said absolutely no filing fees for protection orders. So it won't cost you any money to file a petition for a protection order. You get that filed. They will give you what's called an ex parte hearing, and what that means is you get to go and see the judge without the other party being there. In general, that's not considered fair under court law, or under court rules, excuse me. But in the case of a protection order, the judge will see the person that petitioned usually the next day. And if you file on a Friday, then it will be the following Monday. If the judge hears your explanation of the event, they will grant you another hearing in about 14 days. And between that ex parte hearing and the next one, they're going to serve the other party. They're going to serve the person that's accused of being an abuser. The sheriff's office does that for you, and you don't have to pay for that service either. So service of a protection order is also free. It's important to show up for that next hearing, because that's your chance to tell your story to the court and testify, and it's the other person's chance to come in and tell their side of the story, and then the judge makes a decision about whether protection order issues or not.
So on that, the ex parte, if it happened that way, the other party doesn't know.
Right.
You have to wait till it's notified. So on that time, are you protected or not? Is anything you are granted the protection or not?
Right, no. So until the other party is served, the protection order is not technically in force. So you'll get the protection order at that ex parte hearing, and then they will immediately try to find the person to serve them with notice of it. But if they are not able to find that person, then there's technically no enforceable order at that point.
But if they get them served, then they're protected, until the other hearing.
Until the next hearing. Yeah. So if the judge...
Until then, they're just bait.
Well, the law enforcement's really good at this. They do this all the time. And so usually they find the person accused of being an abuser, almost every time. If they don't, it's usually because the abuser has got wind that some kind of legal action is in place, and so they're hiding out and they're not bothering the victim anyway. Does that make sense? Did you have a question?
Most of them, don't they go into some type of shelter?
Abuse victims, or?
Yes.
You know, I don't see that happen very often. We have shelters across the Treasure Valley, so there's the Women's and Children's Alliance here in Boise, there's Hope Store, there's the Nampa Family Justice Center in Nampa. And certainly those are all good resources. They have a lot of, connections in the community that they can refer victims to. Most of them may have a shelter where abused people can go, but the reality is those shelters often have a wait list themselves. So with a protection order, you can be granted what's called a move-out order, and so the court has the authority, once the sheriff serves this person that's accused of being abused, they can forcibly remove that person from the home, so the victim can stay in the home if that's what they want. Additionally, the judge, if they grant the no contact order, they can grant that the two of you don't have any contact with each other. They can make a temporary custody and visitation order under the domestic violence protection order. They can forbid an abuser from being on the same premises as the victim. So, for example, if the victim and the abuser live in the same neighborhood and the victim goes to the grocery store, then if the abuser shows up under the order, he's supposed to leave because he's not allowed to be in the same place as the victim. The judge can also add protected addresses to the protection order. So kids' schools, the house where the victim is still living, her workplace or his workplace. They can put daycares on there if they need to. And the order will also often have what we call distance restrictions. So, for example, if you are at a child soccer game, the abuser has to stay anywhere from 100 to, I've seen up to 1,500 feet, but that's not very common. But essentially a distance restriction saying you have to stay this far away from the person if you end up having to be in the same place, which is why it's usually making more sense for them to just leave. Yeah.
How do they enforce it? Say like that I have my children who go to the certain school, I never want to move them because all the friends are there, right?
Mm-hmm.
And say like that this abusive husband of mine wants to take the kids up from that particular school. And then, I mean, he was told not to, but if he chooses to, he can go, right?
So if the protection order provides for custody of the children, so let's say you get a protection order and the judge grants you temporary custody of the kids, you can put the school as a protected address on the protection order. Then you take the protection order to the school, and they should not let him leave with those kids because
so
they've got
the school to respect that.
Mm-hmm, mm-hmm, yeah. Or the school can call the police and just say, hey, because the school isn't obligated under the order, right? Like they're not a party to the protection order.
But if it's a grocery store or something, it's going to be a lot more complicated.
Right. But at the school, if he shows up, they should have the protection order on file, and then they should be able to call the police and say, hey, we have a protection order on file. He's here. Please come make him go away.
Or yourself as a victim, you can call the police.
Or you can call
yourself,
as
you
well.
can call the police
Yeah.
and then say, hey, he's here. He doesn't supposed to be here.
Most of the schools that I come in contact with really do want to be as helpful as they can, and so they will often call the parent who has a protection order and say, hey, he or she's here, and then you can call the police as well and let them know. But they usually will not let them leave with the kids. I have not seen that happen. So, the order under federal law can prohibit the abuser from owning guns or ammunition. And then generally the order is the abuser's responsibility. And what I mean by that is even if the victim texts or calls, if there's a no contact order in that protection order, the abuser is well advised to not reply because they're going to be the ones held accountable for not obeying that order. Does that make sense? The other protection order in Idaho is the stalking and malicious harassment protection order. The major difference is under the stalking and harassment protection order, you can't be granted custody of your kids. So it doesn't deal with custody at all. You also don't have to have the same type of relationship with the stalker or the harasser under the stalking and harassment protection order. So it doesn't matter if you don't know the person. If you are stalking or harassing them, you can still go get a protection order against them. If it's, your cousin, you can go and get a stalking and harassment protection order from them. It's a different relationship qualification.
Is that order under a new law, a relatively new law?
Yeah,
2
that
years?
came into place, 2015 or 16?
16.
So
July.
a person who was experiencing something in 2014 or 13 and was unable to get an order because of their facts not fitting the domestic violence definitions, they might be able to get help now because the definitions under stalking and malicious harassment might offer them
Only
a remedy.
right. Only if the conduct is still happening.
Okay.
So and in the stalking and harassment protection order, there's a timeline. There's none in the domestic violence one, but in the stalking and harassment protection order, when you fill out your petition, the behavior that you're seeking protection from has to have happened within the last 90 days.
Okay, so if that person, because they never were able to get any help and didn't think they could up till now, that person continued the same conduct with them and has been doing it recently, they now might have a remedy.
Yeah, then they might have a
never had
remedy.
before
Yeah,
and
they
never
have
knew
before.
to go ask for.
Right. So there are a number of ways you can, or a number of behaviors that fit under the stalking and harassment protection order. One of them is called malicious harassment. So if somebody is threatening you with harm, has actively harmed you, or is threatening any of your family members with harm on the basis of your race, color, religion, ancestry, or national origin, you can get a malicious harassment protection order. Because again, you don't have to have a relationship with the person doing the harassing. You can get a protection order if you are being stalked. And stalking is a course of conduct, so usually the court is looking to see, has this happened more than once? But it's a course of conduct within the last 90 days where somebody maliciously and knowingly annoys you, alarms you, harasses you, causing you substantial emotional distress is what the statute says. But if you are really scared or just really freaked out by this behavior, then you might go ahead and try for a protection order. Now, the course of conduct can mean things like showing up at your workplace multiple times, showing up on property that you've told them they're no longer welcome on multiple times. It can mean following you around town when you ask them to leave you alone. But it also can be conduct that you don't want, even though you've never told them you don't want it. Does that make sense? So to get a protection order, you don't have to prove that you've asked them to stop and they keep doing it. It can be any kind of non-consensual conduct that's obviously made to cause you distress. Is that okay? And then the last thing that you can get a protection order for under the stalking and harassment protection order is telephone harassment. So anytime somebody uses the phone to harass, annoy, terrify, threaten, intimidate somebody else within the last 90 days, you can get a protection order for that. And usually what the judge is going to be looking for were their text messages, were their emails that were lewd, they had like sexual content that was inappropriate, were there threats of some kind of injury or harm to the person or their family. And the telephone itself, it can mean like the old landlines that I don't know that any of us have anymore, or it can be anything that happens on a cell phone. So that's why email can count, social media, like Facebook messaging. If those get, threatening or annoying in any way, you can seek a protection order for that. Under the stalking and harassment protection order, the judge can still grant no contact. The judge can forbid the stalker or the harasser from being on the same premises as the victim. And the judge can still protect addresses on the stalking and harassment protection order. So, don't go to their home, to their school, don't go to their workplace, and they can put the distance restrictions in there as well. It can also sometimes result in you not being able to own a firearm if you are the person found to be the stalker or the harasser. Once again, it is the person who's being accused of the abuse that's responsible for not contacting the victim anymore, even if the victim texts them. The person who's liable or who the court said, yeah, you're harassing them, it's their job not to text back. And then, like I said earlier, no custody or visitation provisions. And there's still, though, because sometimes stalking and harassment happens between intimate partners, there's still a move-out order provision on the stalking and harassment protection order. So if the parties happen to be living in the same place, you can have them removed under the stalking and harassment protection order. And that's kind of it. Questions?
I had one more quick thing to add too,
Sure.
regarding, because I know I just kind of touched on divorce proceedings per se. For a lot of people get very upset because they don't like the child custody arrangement that's been ordered by the court. I shouldn't say a lot. Some people, yeah. Because most parents want more time, and unfortunately they're now going to have to split the time with their children. It's important to tell people that just because this is how it's ordered now doesn't mean it has to be like this forever. There's things called a modification, and you can only do it with child custody portion. So anything that's property is going to be taken care of in the initial divorce. Child custody portion and visitation can be dealt with again later on under modification. Under this, there has to be a substantial and material change in circumstance, though. So let's say, for example, mom got the apartment, dad had to move out. Dad couldn't find an apartment in time before trial, so he got very minimal time with the children. So after he got his ducks in a row, he got a new job, he was able to get an apartment. Let's say a year down the road, he was able to get bed set up and a great house and a great location close to school. He can go ask the court to give him additional time. that he's now situated in a better position, and that would be a substantial and material change in circumstance, because it's something different now than it was back when this first proceeding happened. And that's really important, I think, for people to know, because a lot of people get completely stressed out when they see this final judgment, thinking, oh my goodness, I'm only going to see my kids one night a week for the rest of it till they're 18. And that's not the case, so long as there's that substantial material change in circumstance. A follow-up to, I don't think I finished your question with me earlier regarding when you asked the timeline for divorce or custody proceedings. Right now, at least in Ada County, custody and divorce proceedings, if they're contested, so there's people arguing still, or they're not in agreement, a settlement, I should say, is a better term, is it can be, I think we're seeing about 8 months to 14 months out now from beginning to end. And that's because there are so many people in this system so far. So that's why when I mentioned that there's an opportunity for many times to mediate, there's going to be a lot of time, but also it kind of allows people to work things out. And there's something you can do directly in the middle of everything to kind of test things out. It's called temporary orders. There's a way to ask the court, so you don't have to wait that 14 months to figure something out. You can ask the court to make a preliminary determination, or I shouldn't say preliminary, a temporary determination on what to do with the kids or assets or something during this whole, 14 months of, I don't know what's going on. Who's going to pay that power bill? Who's going to pay, who's going to take the kids to soccer practice? Such like that if the couple themselves are unable to make that determination, they can ask the court for help. So the court can issue this temporary determination, and a lot of the times people use that to see what works and what doesn't. Are the kids going to be successful on a 3-night on, 3-night off? And I always tell people this is the time to try that out, because once that final judgment is entered, you have to meet that substantial material change in circumstance. So if you guys want to agree on some type of schedule right now to see if it's going to work, if it's going to be successful for you or the children, that 14-month time period is a good time to do it. And the judges like seeing that, because then you're providing yourself some guidance and some procedure for it's a very hard time in their life, and a lot of people see the 8 to 14 months and are very nervous because they don't have any confirmed things. So if one order can say you get the truck and you get the car, that's a huge weight off of people's shoulders, knowing that the other spouse isn't going to come take their car away from them. So yeah.
I'd like to share something. It's not so much a question. I work for Intermountain Fair Housing Council, and sometimes in domestic violence situations, when the people live in a rental property, the lease will have a lease violation that has to do with criminal activity on the property. And so in the past, sometimes the whole family will end up evicted because of the domestic violence that occurred. Mm-hmm. The Fair Housing Act prevents that in conjunction with the Violence Against Women Act, to allow the court to bifurcate or split the lease so that the victim can stay in the property and the person who committed the violence can be evicted if the landlord wants to evict them. And the way to go about that is you probably will get a little help with it. We do them for free for people who need them. Is a reasonable accommodation request. It's a quasi-request that instead of a proof of need has a declaration from the victim, sometimes supported by a restraining order or a court order that identifies that the violence did occur, or a witness statement. And that tells the landlord that they can't evict this person for being the victim of domestic violence. It's not a reason that they're allowed to evict them.
So you say, what act is it?
So-
Act against a woman.
So it can, it's, okay, so far the Fair Housing Act says that women,
Okay.
Women of color and women with children are disproportionately affected by domestic violence. It more often happens to women. Could it happen to a man? It could, and I would write that reasonable accommodation request for a man as well, to protect a man, but there hasn't been a court case to solidify that one would be successful.
Okay,
The
but
ones for women so far have been
can protect
supported
those.
by case law.
Can protect also men.
Maybe. The courts haven't made a decision on it. The courts haven't made a decision on it.
Because on your
I
side,
think it would, but
domestic violence, it can be both either, right?
it can.
Yeah, statistically, and it's been a while since I've read this research, statistically I think only about 10% of cases impact men, but it absolutely
Both can be a victim of that. Okay.
Yep, I would definitely write that, and then we would have to go to court to find out if it worked.
And
Alright.
yeah, one last little tidbit I had that I wrote a note about is, please, if you are advising or helping someone with litigation or yourselves, please read everything you get from the courthouse. Please, because there's so many important things that they will get. Please, if you're meeting with individuals, tell them to bring everything they have, even if it's a crumpled bin of papers, something, because there's going to be important dates on there. There's going to be important names, numbers, contact information. The court in Ada County is not a scary place. In any county, I should say, but I'm more familiar with Ada. And they're very dedicated people there that love and pride themselves on helping individuals from the community. And so if you have, like, on your papers, you're going to have your case number, you're going to have maybe your judge's name, and it's just kind of identifiers to help them get to the right place. Another important thing is, please tell them to make sure that their addresses are updated. There more times than not, I have individuals saying, well, I didn't get it. So they go up to the courthouse and they check, and it's, their apartment that they had 3 months ago, but now, they got this protection order and they decided they had to move out. Well, all their stuff was going to their old place. They missed a conference, they missed a hearing, they missed all this stuff because they did not update their address at the courthouse. And I'm assuming there's probably, I don't think they give out your address.
They will give out your address if you're representing yourself, because you have to have a way to serve each other paperwork. And so they won't give out your address to just anybody, but when you change your address with the court, you have to file, and this is in the court assistant's office as well, you have to file a notice of change of address, and you have to notify the other party as well as the court that you've changed your address, so that way everybody can keep getting documents to each other as they need to. One
thing too is it doesn't have to be a physical address.
Right.
It could be a P.O. box, or it can be one of their community members' office address that they're, but please note that if you're sending it to this community member's office, you are telling the court that I am going to be dedicated to look at this. I am approved this place to get my mail, and I'm going to be held accountable for going to get it from this place.
Right.
But we've seen that in a couple of domestic violence cases where the individual didn't want to have their personal home address, and so I would also probably go a step further to advise the court that you are not at that actual address, but that's where you're receiving mail at. Because every once in a while the court will send you some immediate documentation that needs to be reviewed, and you only can get over there once a week or so and so forth. So, yeah.
One question I had, during all these proceedings, who pays the kids' support, and how does the court determine that?
So for child support, correct?
Child support, right.
So Ashley was talking about a temporary order. So sometimes the court will go ahead and make a temporary order for child support. However, if the parties haven't exchanged enough information with each other for the court to say, okay, this is how much money you make, and this is how much money you make, so here's how we're going to split financial responsibilities, I have seen the court make a party in need of child support wait until trial or until settlement. So.
And then they have to pay back support?
Not necessarily. It depends on how they asked for it in their petition.
Okay.
But you can only ask for back support up to the date you filed your petition. So, yeah.
Do they enforce it? Because I'm sure a lot of the people choose not to pay or cannot pay, and that whoever who has a child basically short on money.
You can have your child support order enforced. You have to call Child Support Services, but they won't. Child Support Services doesn't automatically enforce it unless they notice the arrears or the amount that you're in debt has built up to $2,000. Then they'll take notice and they'll do something on their own. But until you hit that point, if you're not getting child support, it's your responsibility to call Child Support Services and ask them to enforce the order. And then if that still doesn't work, then there are contempt proceedings, but that's a whole other subject area.
We don't like touching that part.
Yeah, it's all of our least favorite things.
And on this case, we were waiting to help our people to fight this proceeding. It takes a lot of time, knowledge. Were you guys waiting to help the people? If you so, how can we get hold of you guys?
So for me, I work at Idaho Legal Aid Services. I can only do family law if there are allegations of domestic violence, and I can only take protection orders, of course, if there's some kind of allegation of domestic violence or stalking or harassment. There is the street law clinic where Ashley volunteers. That's every second and fourth Monday at the Boise Public
Correct.
Library.
Yep.
Yeah. And that's what, from 4:30 to 6?
Or 4 to 6. I always tell people to get there a little bit early because earlier you're there.
There's a line.
Yeah,
Yeah.
you can get out. But what the street law clinic does, and this is what I would totally recommend anyone who has individuals with questions, to come down to the Boise Public Library, and they will sit with a student, and the student will figure out their legal issue with them. And then there's a group of attorneys in the back where the student then will take the person's legal issue, work with the attorneys, kind of round table, discuss, figure out how to get that individual's question answered, and go back out to that individual and reiterate their information to them. The best part is they can come as many times to this clinic as they want to. We have several people who have worked themselves through the legal process by coming to every clinic. So just because you come 1 or twice or 4 times, you can come every single clinic until you're successfully completed your litigation.
And there's no income limit.
There's no income limit.
Any income can still come and get free help.
Yep, exactly. And there's one thing we can't do is fill out forms for people. So if you guys can at least get them set up to bring their forms in, or go through them and or just sticky some questions or whatever else, we can go through those and help them or guide them better. We were joking because it's very hard to sit down and try to give you guys a spiel on what we do, because it depends. There's so many different things that can change with someone, and better to guide. And so we, by them coming in and explaining a situation, we might be able to get them directly on that temporary order route. Or maybe they're a total mediated case, they just need some figure out what to do with this debt. That's something that we can help them with in this clinic, and then they can come back to you guys and be like, look at all this cool stuff we learned, hopefully, fingers crossed.
So in this legal clinic, what you focus on? What discipline do you?
It can
do
be any
everything?
kind of discipline. We
Okay.
try really hard. There's about between 6, 8, every once in a while there's about 10 students or 10 attorneys that are there with every type of background.
Okay.
So if every once in a while we'll get some kind of funky issues, like we've been trying really hard to have a Social Security attorney there recently, because there's been a lot of those type of issues going in. And if there isn't one there, family law, there's always going to be someone there. But if there's landlord tenant, there's generally someone always there. Some of the other funkier issues of law, we most likely will get their contact information, have someone contact them. Another important thing is, I believe, and I think one of my street law people are here in the back, he might be able to answer this for me, but I believe this clinic just received a grant for interpreters, that we can use for interpreters, which is huge. And that was on my list to explain today. But thing is we need to know ahead of time to arrange the interpreter, because if we're paying for an interpreter to be there every time, we use up the funds too quick when we could hopefully carry it out a lot longer. So if we know of someone that wants to come in that needs
Call
an
in
interpreter,
advance and let
yes,
you know.
and let us know. And bonus points if you know of someone that we can contact as an interpreter, because we're still trying to. The courthouses have their interpreter lists and such, but a lot of them don't want to work after hours, and ours goes till 6. But the way to get a contact, it's itla.org, so itla.org. That has all the contact information and information about the clinics and stuff on there. The 2 gals that run ITLA are Barbara and Avery, and they're wonderful. You can call them and they can help tell you when the clinics are. They can set you up with, maybe we've had several times when people, and I think I've even asked Lessie to help a couple times, when there's been an emergency, when we get a phone call at our own offices from ITLA saying, hey, this person needs to have something filed tomorrow, can you spend 10 minutes talking to them on the phone? And that's an average thing. So even if your individuals have an emergency before the actual clinic, please have them get in contact with ITLA, because we try really hard to at least get people on the straight path to kind of help them.
What does ITLA stand for?
Oh, thank you. Idaho Trial Lawyers Association. So it's a group of people who love clinic and want to give back, and yeah, it's a lot of fun. And I invite all you guys to come down and check it out too, because once you see what it's kind of about, you'll probably be able to better guide people on what to expect when they come in.
Plus, you can go on the website for Equal Justice Committee, and there is a thing you can push for sources of legal assistance.
Oh, cool. Awesome.
The Street Law Clinic is on there, the contact information. There's also contact information for Idaho Legal Aid, contact information for Idaho or Intermountain Fair Housing, and also for the Idaho Volunteer Lawyers. 100 lawyers in the state, in fact more than 100 lawyers, have volunteered to handle specifically refugee requests for assistance. For Idaho Volunteer Lawyers, it's for low-income people, but they handle a wide range of problems. And
So who's qualified for that?
Pardon?
Because we've been having trouble. We thought like everybody can access that, but it's not everyone.
They have to be low income.
Correct. But we've been told that we have to come through agencies.
But they have to be referred by
By
which,
agencies.
which agencies?
IRC or Catholic Charities or
I
some
don't-
of them. Yeah,
I
because
don't think so.
correct, because
Anybody,
But that's what he's experiencing.
that's the experience. I have an
This is what
email
he's
because
experiencing.
I have an email. I emailed Anne. Is that Anna?
Yeah, and
Anna,
America,
right.
she's
Yeah,
leaving, just leaving.
Correct. So I sent the email because last meeting. That's why we understand everybody can refer the client there. We
Right.
have the form. We fill out the form. We send to them.
Is
And-
that about citizenship?
Correct. 648, because that's why my understanding on last meeting, they were there, they present, they say everybody can go there if they're qualified. They have like their intake form, which we fill out the form, and then we send to them, and then they send back email, they're like, you have to be referred by any agency.
So I will take that back to them. I have Sue and Anna are my colleagues, and
Okay.
I think there's a staff member at the front end who vets in ways that maybe that staff member shouldn't. And so if that's a conversation they need to have with that staff member, I can pass
That's
that on.
actually what we, probably 3 years ago, we met with agencies because we have BIA accredited people that work with immigration, and we established the process for people that they are applying for citizenship, that actually they will come through resettlement agencies, that we can see that they are low income, that we kind of assess the situation and send information to that group that they can meet and find interpreter and meet with the clients.
Okay. And
Yeah.
is that for Idaho Volunteer Lawyers Program in particular?
Yes.
Okay.
But just for immigrant, for citizenship, for seniors or disabled people. Everything else can.
Cold call, right?
Yeah, because that's
Because
okay.
we had several instances where actually community members were doing immigration applications, and then they would not sign off on them and make mistakes, and then the clients would be responsible to fix the problems, and that was the reason why we made a process.
But the issue also is like if the client doesn't want to go to the agency, or they don't have a fund, or they don't have money to go to the agency, they should have an option or choice where to go. Because if the community member don't know what they're doing, they go to ask for the help at the volunteer lawyer, and the volunteer lawyer send them to where the client probably doesn't want to go, and then now the community member is forced to do what he's not supposed to do. Because if the client is asking me, hey, help me to fill out this form, and then I say, I don't know how, and then I take to volunteer lawyers. And then or I say, go to so agency, and then he say, no, I don't want to go to that agency. Okay, I say, okay, let me take to volunteer lawyer, go to volunteer lawyer. They say, no, go to the agency, and then I tell the client, and then the client is like, I'm not gonna go there. So I'm forced to go ahead and then do, or he's forced to go to find somebody else who's gonna take advantage of him, when we understand, this program is open to the people. Anybody can go to whoever he wants to go to. But in that case, we're going to force them to go the route they want to go to.
It's not forced, it's just the 3 resettlement agencies
Correct.
at that time had actually people that they are BIA accredited, that they know what forms they need to fill out. And clients, if they don't want to go to one agency, they still have a choice to go to other 2. But the process was that, okay, they will come, we will assess the situation if we have, because it was very hard to fill out applications because people did not know the date of birth, they did not know their kids' names, and the resettlement agencies already had that information to actually make the process easier and provide information that was legally received.
Yeah, but an issue like that, you have a family member, because I'm talking from experience. Somebody have like 3 people in the family. So the agency say, okay, we're gonna help one, but the other 2 they wanna pay.
So I have no dog in this fight. All I can say is a useful service is turned on its head. And so what is the protocol? Because this was supposed to be helpful, and instead it became a barrier. Right? So you guys just have to work out under what conditions. Are you making sure that that flow of information is correct? Because see, he's objecting, right? I mean, you're upset about this.
Yeah,
right? I mean,
correct, because the last minute, like I said, the last minute.
No, I understand. My point is, this is totally the opposite of what was the intent.
Correct.
All right? So I think the thing is, it's like, do people not understand? Now, of course, if you have people going to unqualified help, that's not a good thing. So I think it's just a matter of exactly what just happened, which is making sure that on those referrals, the information is given. So if that understanding, though, is not happening at the point of the referral, that needs to be reviewed. All right? So,
Can I add something to this one? IRC has free services for citizenship, so clients are not forced to pay a fee. If people don't have an income or they're low income, and they have services and they have clinics for citizenship that is going on, just to make sure what happened with volunteer lawyers. I was involved in that meeting too, that clients went there, and again, agencies received call. What's the A number? Or where is this paper? Where is that paper? So that came out of all challenging to better serve the clients, not the agencies, or an income for the agency, how we can make that process, easier for the client to get the service, especially with seniors and visibles. If they don't get their citizenship within 7 years, they lose all the benefits. How we make the process smoother, that the client get easier. Because we're not objecting where they go, we don't force people where to come because they can go anywhere they want, but if there is a mess, we are not the ones to solve the mess because we don't know what happened. We want to help the clients and educate them and know about their rights and responsibilities. And definitely there are few services available for them with people who have the knowledge and they're legally allowed to work with refugees. And that can be, again, a meeting and talking to them what their process can be. It's not against the clients. We're all here to support that group. This meeting is for that reason, how to pass this information there. I know what to do, she knows what to do, but we're here how to get resources to provide back to refugees.
everybody happier?
Yes,
You feel like you're going to be able to get to a better outcome.
Where though?
Oh,
Information.
so
Again, like I'm saying, where's the information? Who does the thing? Because she's saying like IRC is providing like a free services, which I contacted the IRC, and then they say no.
Oh, no, I understand.
So you know what I'm saying?
This,
So it's just like the things
right,
that,
right. So my point is that it's like at this point I would start diagramming and I'd say, this is the part that needs work. So it's like I get on the board and I say, well, what's the problem here? And then, because you're walking away, which is what I suspected, you're still not happy.
no, but again, like I said,
No, I understand.
like
but
I said,
mean,
where's the information?
That's the
You
problem.
see,
It's
they say
kind
they're
of
gonna
like, how do
provide
you
us
get
information.
to a root cause fix for this?
Yeah. So because we don't have no information, like she say, IRC has.
No, I agree. That's not me.
Like
I have.
She say IRC has the
I
free
have no-
services, but I talked to
No,
them,
I
and they
agree.
say no.
I have no stake in this
That's
argument.
what I'm saying.
No, I know. I have no stake. I'm just observing. There's still a gap here, and I'm saying the way I would, in my profession,